The Constitution is clear, or so we thought. For over a century, anyone born on American soil automatically became a citizen. But what happens when a president signs an executive order attempting to change that with the stroke of a pen? The Supreme Court is about to decide, and the outcome could reshape American identity itself. On his first day back in office, President Trump signed an executive order that sent shockwaves through legal circles and immigrant communities across America. The order declared that children born in the United States to undocumented parents would no longer automatically receive citizenship. Within hours, lawsuits flooded federal courts. Civil rights organizations, state attorneys general, and advocacy groups all lined up to challenge what they called an unconstitutional power grab. Now, months later, the nation's highest court has agreed to hear the case, setting the stage for one of the most consequential immigration rulings in modern history. The principle at stake is birthright citizenship, enshrined in the 14th Amendment since 1868. The amendment states that all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens. Those 23 words have defined American citizenship for generations, creating a clear and automatic path to belonging for millions of children born on American soil. This wasn't an accident of history. The amendment emerged from the ashes of the Civil War, specifically designed to overturn the infamous Dred Scott decision, and ensure that formerly enslaved people and their descendants would be recognized as full citizens. The Trump administration argues that the phrase subject to the jurisdiction thereof creates an exception. According to this interpretation, children of undocumented immigrants are and truly under complete American jurisdiction because their parents owe allegiance to other countries. Administration lawyers point to historical examples like children of foreign diplomats, who aren't granted automatic citizenship despite being born in America. They argue this proves the 14th Amendment was never meant to be absolutely universal. Legal scholars across the political spectrum have expressed deep skepticism about this argument. The Supreme Court addressed birthright citizenship in 1898 in United States versus Wong Kim Ark. That case involved a man born in San Francisco to Chinese immigrant parents who were prohibited from becoming citizens under the racist Chinese Exclusion Act. When Wong returned from a trip to China, immigration officials denied him re-entry, claiming he wasn't a citizen. The Supreme Court ruled decisively that he was indeed an American citizen by birth, establishing that birthright citizenship applies regardless of parents' immigration status or eligibility for citizenship. Constitutional experts note that the jurisdiction phrase was understood at the time to exclude only a narrow category of people, specifically children of foreign diplomats and enemy soldiers occupying American territory. Everyone else born on American soil, regardless of their parents' status, became citizens. This interpretation has held for over a century through administrations of both parties. The practical implications of this case extend far beyond legal theory. Approximately 300,000 children are born each year in the United States to parents who lack legal status. Under current law, these children are American citizens with all the rights that entails. They can vote when they turn 18, run for any office except president, and never face deportation from the only country they've ever known. Eliminating birthright citizenship would create a new category of people, permanently stateless individuals born and raised in America, but denied citizenship and the protections it provides. Immigration advocates warn that such a change would create a hereditary underclass, potentially spanning generations. Children without citizenship couldn't access many government benefits, might face difficulties getting legitimate employment, and would live under constant threat of deportation to countries they've never seen. The administrative nightmare of determining citizenship status for every newborn based on parents' immigration history would be staggering. Supporters of the executive order counter that birthright citizenship creates incentives for illegal immigration. They argue that people come to America specifically to give birth so their children will be citizens, a phenomenon sometimes called birth tourism. They contend that most developed nations do and have unrestricted birthright citizenship, and that America should align its policies with countries like Australia and the United Kingdom. However, immigration researchers note that birthright citizenship is the norm throughout the Americas, from Canada to Argentina. Moreover, studies consistently show that people migrate primarily for work, safety, and family reunification, not for their future children's citizenship status. The Supreme Court's decision will reverberate far beyond the parties directly involved. If the court upholds the executive order, it would mark a dramatic expansion of presidential power, and a fundamental reinterpretation of constitutional text that has remained stable for over 150 years. If the court strikes down the order, it would reaffirm limits on executive authority and the enduring nature of constitutional rights. This is Visa Guide USA, and we'll be following this historic case closely. The oral arguments are expected within months, with a decision likely before the end of the term. Whatever the outcome, it will define American citizenship for generations to come. Make sure you're subscribed so you don't miss our coverage as this landmark case unfolds.